USCIS narrows the applicability of the Child Status Protection Act. That's everybody on YouTube's talking about this. Every attorney in the country is talking about this. It's one of the dumbest decisions I have seen coming out of this administration. Let's face it.
I'm going to blame it on the prior administration for making a dumb decision in the way they implemented it in the first place, but we'll talk about that.
Basically, what this decision does, it allows less children to join their family members
in lawful immigration,
in lawful immigration process, at no additional green cards to the quota.
Yeah.
So the number of green cards allocated is 140,000, right? 140,000, and then you have the crossover from family immigration.
Yeah.
Then it's allocated to green card holders through employment and their family. On the family side, through the family, there is a number.
Yep.
That number will not be exceeded.
Yep.
This policy revision, reversal, separates family.
Yep.
There's no more green card given. There's no less green card given across the spectrum.
Yep. Agreed.
Family or employment, all what it does, it separates children from their parents.
Yep.
And that's the only thing it does.
Sounds like you're finished up, but we're just getting started, Sam. Who are you?
I'm Sam Shihab with the law firm of Shihab Burke.
I'm Brian Burke from that very same place.
And I just cannot believe that we're dealing with something like this. This is an administration that passes policy for the sake of passing a policy that is not exactly well thought of, except that it is opposite of the prior administration.
Yeah.
And that's very sad.
Well, yeah. So, I mean, let's talk, as I said earlier, the prior policy, going by the dates for filing in lieu of final action dates, that was like sort of a gift from the prior administration, I think it was, right? Sometime in the 4-year block of President Biden, we woke up one day and they said, oh, they changed the policy on Child Status Protection Act.
What is the Child Status Protection Act?
Okay.
In 6 words, maybe 7 words, quickly.
Such a challenge, Sam. Child Status Protection Act gives your child the benefit of time while your immigrant petition is pending to allow them to immigrate, or otherwise, say in immediate relative cases, locks in their date of immigration, their age of immigration, under the age of 21 for longer than it might otherwise be.
It's what the title is. This is an excellent title. The status of the child is being protected, okay, through government process, and they're not aging out.
Well,
so that's what it does.
Yeah.
So that's the CSPA.
Yes.
Now, amazingly, a simple, very logical rule becomes incredibly complicated to calculate. It's one of those things that when you bring it and start calculating it, there is so many nuances to it and becomes very difficult.
Sure.
But there is a very basic common sense rule that the prior administration proposed is, hey, if you file your application, okay, if we tell you you can go ahead and file the application and you go ahead and file it, and you file it correctly, we can protect you.
Yeah.
This administration says, not so fast, my friend.
And that's fair, I think. I mean, because what? We're going to take, so the prior...
How is it fair?
No, the old version was fair.
Yeah.
It's basically, before they changed it to dates for filing, there's a possibility you could file the I-485 with USCIS, when you're allowed to file it, and they'll come back later and say, no, buddy,
Thanks for paying.
Thanks for your money. We love it. We're going to make it into a shirt for ourselves, and nuts to you, we're denying your child's green card. Which
is insanity.
Yeah, it's rude and mean. And that policy, like I said, we woke up to it one day. Awesome. More kids are going to get green cards. Less parents are going to be feeling guilty for, not immigrating to the United States early enough and depriving their child of the opportunity to immigrate with them. Great. Now, Sam, I wanted to get into it. The only problem I had is the way they implemented this abide by dates for filing during the prior administration is they did it by just sort of putting it on a government website somewhere. I believe they put it in the USCIS policy handbook.
Policy member.
Yeah, policy handbook. And you know what's the real downfall of that? The next administration can come back and just totally undo it. Here we are.
With the same policy.
With the same policy.
So you're saying that they should have put it in the Federal Register.
They should have. Well, they could have.
Changed the regulations.
Yeah. What I always hope for things that are good for immigration is a change in the law, as we were discussing earlier. Not like they changed the immigration laws much. Impossible, hot potato they don't want to touch. But they could have at least regulated. It is harder to do undo a regulation. It takes them longer to undo a regulation, and they might not care enough to undo a regulation. All it takes to undo a policy is just, like you said, write a new policy memo. They're done.
Is there any reason why this policy makes any sense?
Matter of perspective. I could allow less people that are beyond the age of 21 to come to the United States, to immigrate to the United States. If that's what my goal is, sure. Don't let parents bring older kids, essentially, is the logic.
But family unity is the basis of our immigration system.
100% agree, but the counterpoint is they're over 21, they're adults now, they can fend for their own wherever they're from, I don't agree with it, but I will.
Not sound reason, because it flies against a law that passed called the Child Status Protection Act, which is basically we're going to create laws to protect the children from aging out, so they can join their family when their parents come to the U.S. And now we create these policies to counter that, to offset that. And
how they implement it to make it as most useful as possible.
There is no positive. There's net zero positive. There's no. Even your argument has no basis in logic or common sense. With all due respect. No, it doesn't. You're trying, but it's not reasonable.
Well, your position is the bottom line, Brian. I'm going to put some words in your mouth. The bottom line is it doesn't change the number of family-based visas available. It's not like you're stuck. It doesn't change. It doesn't change. It doesn't change the number of people coming to the United States. It just maybe changes around who they are, because some kids are going to be locked out by their age.
It separates children from their family, kids from their. It separates family. This is a rule that separates families, and that there's no benefit.
Well, again, I'm going to say that if you're, not my perspective, but there's sort of two versions of it. The version that we are going by final action dates, gives less time back to kids, right? Meaning
more children are separated from their family.
But basically, under the old policy we had for a couple years there, it's basically people who are older could stand a better chance because they're going by dates for filing instead of final action dates. And now it's going to say maybe same number of people getting visas because it's the same number of visa availability in all these categories, but the people who get those visas that are protected by this act are going to be younger than previously in the past. If you think that's a benefit,
there is absolutely no benefit of having children who just turned 21 to not join their family.
And
they can stay back. And their parents leave them and come to America, and the child the son and the daughter who's 22 years old cannot come in. There's absolutely no benefit to this country.
Agreed.
By doing that.
Agreed. I 100% agree. I guess the fundamental question, Sam, is, well, can you do anything about this?
This policy will not stand, because what happened in the prior administration policy, it was a common sense policy.
Sure.
It was a natural policy that promotes the essence of what the Child Status Protection Act. When you step back and look at it from a big picture, you're going to say, wow, that makes a lot of sense. I'm taking money from these people. I'm taking $1,400. I'm putting in my pocket. And then later on, I have to be able to honor. Maybe you can create that policy, and maybe you can add a refund policy. You can say, if the Child Status Protection Act,
you had me at USCIS refund policy.
We collected your money, and then we are going to tell you you're not going to qualify at a date that neither one of us knew what's going to happen in the future. We'll give you your money back. But no, they will not give you your money back. And therefore, I think this policy will change in the future. Probably
somebody can change it back.
The next administration.
Do you think anybody attempts to sue on this right now?
Well, there's no damage. There has to be a denial. You know how the court system works. You have to have a standing. So somebody has to be denied. And then somebody will sue, but what is he gonna she gonna sue for? The $1,400 filing fee?
The change in policy, and if not for this, the government's change of policy, I would have gotten a green card myself. Not that I think that's but that person's already out there. They're probably not in our audience, but that person who's getting, the first person to get, for lack of a better term, screwed on this policy they're out there. They are in the world, and that's that.
We will continue to keep an eye on it. I bet you in the next few years this policy will reverse itself. And we move on to answering questions. We get about 20 minutes to answer questions so bring your question in, share your question, and we'll be happy to answer them. And we've received some questions on immigrationquestions.us during the week. and we will answer them as well.
Well, we have a audio file commentary here from Sam Fax, who I think was the one who rang the bell for us about our issue. Thanks for the deep insights. Audio coming in crisp and clear. Now, after last week's YouTube, Sam and I, did some testing, and we discovered that it was my microphone that was causing us problems. So thank you for everybody who pointed out. We have gotten a shiny new microphone, brand new in the box. These things are great if you're looking for a microphone, aside from the fact that they eventually wear out after a couple years.
And they're not cheap.
Yeah, this is true. Yeah.
But Pan Gupta has a question.
Yeah, Pan Gupta. I got my H-1B cap change of status approved by USCIS. Then my OPT application has been pending since May 30th, 2025. Will USCIS deny my OPT or approve it?
What do you think?
I don't see any reason why they shouldn't approve it. Again, I don't know what kind of OPT, if this is a STEM OPT or an initial OPT. But bottom line is, until you are on H-1B status of October 1st, you are still going to be eligible for F1 OPT.
But what happened after October 1st?
After October 1st, well, we're going to be changed to H-1B status.
Will they approve or deny?
Oh, will they approve it after October 1st? I suspect they're going to basically deny it. They might issue an RFE saying, hey, we think you're on H-1B status.
I think they should approve it. I think they should approve it either way. I don't know what will they do, but I'll tell you what they should do because he may not join on
this. Is true. So basically, maybe what you're pointing out here is that your H-1B change of status has been approved, should take effect on October 1st, but that hasn't happened yet. In order to actually make your H-1B status effective, you have to join that H-1B employer.
Yes.
And well, that's that. And meaning if you don't do that, you might have a value left in your F1 OPT. Yeah. However, you always have to be careful with your F1 EADs, because if your school terminates your service record, by policy, as I recall, they'll consider your F1 status to be invalid, and thereby that EAD invalid, as well. So yeah.
And also, if you received an OPT EAD card and an H-1B, once you work on H-1B, that OPT card is nullified.
Yeah.
So don't assume that you can work on that EAD and maintain your H-1B at the same time.
Yeah.
They are oil and water, they don't mix. If you work on OPT, you've invalidated your H-1B. If you work on H-1B, you've invalidated your OPT. And that's how it works.
Yeah. Going to go check out a question here from immigrationquestions.us here. And I'm going to see if, I'm going to, again, pare it down just a little bit here. I think you have a copy of it there because you printed it off like a smart person beforehand, Sam. But the sort of short version of it is F2A the only path to get a spouse of green card holders to the United States?
Well, that's an excellent question. I think one of the questions he's asking is, does it make sense to delay my marriage until I get my citizenship?
Yeah.
And we talked about, we can't answer whether or not you should delay your marriage. If she's an amazing woman and you delay your marriage, she may be marrying somebody else, and that's not good news for you.
Yeah.
So we cannot give you an advice to delay your marriage because we definitely want you to be happily married.
Sam, you've copped out on a factual question. On the legal question, if you're a permanent resident of the United States, you're married to somebody who's not, you can file an I-130 today in the F2A category. And as the person writes in their question here, the consular, to actually get a green card as F2A category, spouse of a permanent resident, it's measured in a couple years. The dates are backlogged pretty well.
It's about 6 months, though, for dates for filing.
For dates for filing.
So you can file it, and then another 6 months.
Well, you're presuming somebody is inside the United States, a spouse of a permanent resident in the United States.
Right.
But I'm presuming
outside the United States, they have to wait for. Well, you can start the consular processing.
Yeah, you can once it's approved, but they won't approve that F2A I-130 for a long time because they know a visa's not going to be available for a while. So, is there any other path to get a spouse of a green card holder to the United States such that they can be with you while this thing is pending.
And I guess back to the question on delaying the marriage, which is, I know I gave a smart-ass answer, but delaying the marriage gives the opportunity for the spouse to come in on an F1 visa to the U.S., and there's no concerns about immigrant intent because maybe she's not engaged, is not married to somebody who's a permanent resident. That'll make things easier.
Yeah, but if they ask about, well, do you have a significant other in the United States? Well,
that's still the truth.
Oh yeah, of course, yeah.
But I'm not engaged. I'm not married right now. We may be doing it, but he has to become a citizen first. I'm paying attention to my studies now.
Yeah, I mean, yeah, that
would be the answer.
That's a good answer. I mean, because your answer, the all-encompassing version of it is, I guess, is there another temporary non-immigrant visa you can use to get this person to the United States? And the answer is, it's rough. If they can independently qualify for another type of visa like F or H, sure, they can come to the United States on that and then, hang out on that status, do what they're supposed to do. But it is not a problem, not a solution that usually manifests, because it's sort of one that can be, hard to achieve is the bottom line, Making an H-1B appear out of nowhere is difficult talk,
I always tell people that getting married and living apart from your spouse is about the most difficult thing you can do. Yeah. And the reason being is that something about marriage creates expectations, right? It's a legal contract, it's a marriage contract, and there's expectations. Whereas when there is a courting going on and there's no expectations, it kind of, the stress is a different type of stress. Mm-hmm. I miss her, I want to be with her. I miss him, I want to be with him. Mm-hmm. Or God damn it, how in the hell my wife is not here in the U.S. with me? It's a completely, it's a completely different mindset. So delaying marriage when your visa is not available until time that's available might not be a bad idea.
Yeah, Sam, I want to take the other take. If you're a permanent resident, you're married to somebody who's not, you can get married right now, file the I-130. I hope you're getting reasonably close to U.S. citizenship. As soon as you apply to you become a U.S. citizen, that I-130 can be auto-magically upgraded to spouse of a U.S. citizen, and suddenly it will be a priority for them. That's that. It really maybe depends upon...
I can give you 10 counters to that.
Yeah, I can give you 10 along way.
Well, no, you would agree with me probably with mine, but we will just cut it here because it's a difficult question.
Yeah, we don't tell people when to get married, I guess. That smart-ass answer of yours from the beginning, maybe that's the right one,
All right, sounds good. So let's go on to the next one.
So let me see here. From Ranyan, a positive update here, I guess.
Whoa, finally, congratulations. Was approved and they opened our case, erroneously denied 485 previously. How long do you usually take after you open the case, usually to approve the I-485? So
I believe we're sort of on the presumption this is an employment one based upon what we've heard from this person in the past. And I have a scenario right like this. Somebody came to me with basically, long story short, as soon as they retained us, they got in denial on their I-485. I turbocharged the motions at the door. Successful motions, and you got some notices they're reopening the case, and I'm still waiting on that same sort of question as well. The answer is I wouldn't count quickly on it, but they reopened the case because they thought there was merit in it. So, that's a good thing.
Well, Runyon can sleep at night. I know it has been very difficult 5 or 6 months for him. Yeah. He's appeared multiple times on our forum, asked many questions, and we tried to answer as much as possible, but not knowing the specifics of the case, our hands were tied. But happy for him that that things are getting back on track again for him, to be honest with you.
Yeah.
All right.
So sort of a follow-up question relating to that. Is there a way to check AP validity so that we can avoid problems in travel? Layers. Layer 1 is that I-485 decision notice, it says, holy baloney, your case is denied, will say, your EAD is canceled in 18 days, I believe it'll say, and your advanced parole canceled, like that. Does reopening a case undo that negative decision, Sam?
They have to do it on their own motion. It's not automatic, Brian, and they should do it. So,
but they haven't issued a negative decision on the EAD and AP.
But if the decision says your EAD is denied, opening the 485 without confirming in the reopening that the ancillary benefits are now active, I cannot assume that.
Yeah,
especially in light of the fact that the consequence of assuming that are serious.
Work without authorization can
and not being able to come back to the U.S.
Yeah, I mean, so that there's something reasonable to think about there. That's for sure. But I'm going to say, doesn't a reopening basically, isn't that them conceding that, well, we shouldn't have denied this thing in the first place?
Yes, but they have to take the affirmative action, in my opinion.
Yeah.
On their own motion, they have to take the affirmative. That's my opinion on this. I wouldn't assume.
Yeah. It's not an unreasonable. I don't think it's an unreasonable position. It also, I guess, the devil's in the details about how these things read as well.
Yeah, because they've taken the extra step of telling you your advance parole is no longer valid and your EAD is gone.
Yeah.
And now we've reopened your adjustment. Okay, continue. Give me more information.
It's a fair answer.
So you need that, I think.
Yeah. All right. Fair enough. Question here from Sweet Seller.
For naturalization, does travel outside the country have an impact? Does the number of days outside the U.S. add to the 4-year, 10-month window? So Sweet Sarah is still having difficulty with that. Maybe we didn't do a good job explaining it. Number one, it's not 4-year, 10 months. It's 4-year, 9 months.
Yes, because you're allowed. Well, okay. So first of all, you're referring to the fact that you can, if you are subject to the 5-year look back, the 5-year statutory period of permanent residence for your citizenship, you can file 90 days before, meaning you can file your case at 4 years and 9 months of permanent residence, right?
Yeah. Now I'm going to answer the question.
Yeah.
It's not 4-year, 10 months window. It's 4-year, 9 months.
Sure.
Window. And the answer is no. Traveling outside the United States does not impact the 4-year, 9 months window.
But travel outside.
Hold on.
Okay.
Hold on.
Okay.
Pause, because that needs to sink.
Yes.
Okay. So traveling outside the United States does not impact the 4-year, 9 months, because we jump too quickly to the additional explanation and things can get confused in people's head. So I just want that to sink.
So
go ahead.
Put that in this box over here.
Yes.
Now, travel outside the United States can definitely impact your ability to apply for a green card. And there's 2 ways it sort of manifests. One is that when you're subject to the 5-year statutory period, there's a requirement that you spend half of that period inside the United States. By leaving the country, as you said earlier, doesn't change the window around, anything like that. But when you hit 5 years of being a permanent resident, or 4 months and 90 days of being a 4 years and 9 months, excuse me, less than 90 days, that's it. You must have to spend half the time in the United States, bottom line. Now, there's also the idea that you can abandon your permanent residence by leaving the country for too long.
You're sever the physical presence requirement.
Yeah.
Which is different a little bit.
Yeah. There's basically
They're similar, but
yeah.
So you sever the physical presence requirement. You have to have at least, you cannot be outside the United States less than 6 months at a time.
More than 6 months at a time. Yeah.
More than 6 months at any given one time.
Yeah.
But there are ways to overcome that, which is not fun to do if you're going through naturalization.
Yeah. They will issue an RFE on the subject if they discover, as part of your N-400 case, that you have a period of 6 months outside of the country, and they'll raise the question of, hey, did you abandon your permanent residence?
Well, it's considered abandoned.
The year, sorry.
It's considered severing. It's considered severing the continuous presence requirement.
Yeah.
Which is, you have to be, because you crossed that 6 months line, and then you have to show that you did not do that, and this was beyond your control, and you have ties to the U.S. And explain it, and they have to accept that. And if they don't accept it, then you got to start counting the 5 years fresh.
Yeah, you're talking about whether or not you're a permanent resident is another question. That's a little bit different.
They're very similar, but they're a little bit different.
It makes my head hurt whenever I read the government policies on this. So yeah. Well, classic us. We answered 5 different versions of the question. Sweet Seller says travel outside the country during the green card is what I mean, and that, again, the answer is I think we've answered that, and I sincerely hope that we got that through. I have another question here from immigrationquestions.us. I think maybe somebody may have sent this live to us here. A good question. Copy. Here we are, adding in the text here. Paste. There we are.
I lost my advance parole, So planning to apply to a pending employment-based adjustment status. Do I need to submit any additional documents like police report filing or anything else?
But I think it's
pending employment-based adjust reply.
I think it's a reapply. I think is I think it's just a minor typo there. Do I need to submit?
Pending based adjustment status.
So
he's applying for a new advanced parole.
I have a pending employment-based adjustment status. I had an advanced parole based upon that.
I lost it. I need a new one.
Yeah, yeah.
Do you need to file a police report? You have to explain what happened to it.
Oh, police report. What happened to? Okay, okay.
To the lost advanced parole. How did you lose it? You can write an affidavit, explain to them that you normally put it in the drawer, and you open the drawer in the spot where you found it, and you couldn't find it. You tore up the house upside down, and you couldn't find it, and you believe that maybe you inadvertently disposed of it.
Yeah.
And you can put that under oath.
Yeah.
Affidavit under penalty of perjury, a sworn statement. You don't have to file a police report against yourself if you do believe it was stolen, was not stolen. You know,
Yeah.
you don't have to do that.
Yeah, I mean,
so you got to handle it. You got to give them some explanation.
Yeah, that's a fair answer in my book. Yeah, yeah.
All right. Okay. Good. All right.
We hit the end of our questions. See if we have anything fresh live from immigrationquestions.us, and the answer is drumroll, no, sir.
So back to the Child Status Protection Act.
Yep.
So estimates, and I think these are absolutely not based on any science. They're saying causing $50,000 children being separated. There's some people saying 120,000
like
children.
estimated impact. I would love to meet the person who calculates that number.
Some people are saying 200,000 children separated, but clearly is going to impact people. Clearly is going to impact people. The time between filing date and the final action date can extend as little as 6 months and as much as 2 years.
Well, our colleague, good attorney Joe Marhart was saying, was highlighting the F2A category for that. It's quite the, it's quite the distance between dates for filing and final action dates. I think it's something like ridiculous, like 2 years, something like that.
Yeah.
Which is huge.
So the numbers may not be scientifically drawn, but may not be off base.
Yeah.
Causing family separate. Who comes out with a policy to separate families?
But again, it's like you said earlier. It's not like people aren't going to get those green cards. Those family green cards are still available, and it's just
it's not that somebody said and decided I'm going to give more green cards to parents than children, and that's why I'm changing the policy. That's basically what you're doing. I'm going to give it to more parents and less children, and I'm going to by doing that, I'm going to deny 22 and 21 and 23-year-old sons and daughters being with their family when their family immigrates to the United States. I'm going to leave them back in the old country, okay, and let their mom and dad
feel like shit.
Come to America or have to make the difficult decision. Okay? It's just like this gentleman that came to me. He said, I'm having a wedding. My child is getting married. We left 2 of our children back home. But we filed an I-130 for them. The I-130 is pending for the last 8 years for some reason. Can I bring my children to the wedding? And the answer,
maybe.
Well, we went through the pros and cons, and it didn't look good. Single and attached, doesn't have a job, doesn't make a lot of money.
Poor. They would have a problem regardless.
Poor. This child will have a wedding without his family members here in the U.S. That's sad. What is the purpose behind a policy that separates family from family? Nothing.
Well,
nothing.
I'm going to give you the alternative take. If you and your family, if you and your spouse and your young child are in the family-based backlog, you might feel a little bit better. You say, oh, we're going to get rid of those people in front of me who are all older than age of 21. Instead of them getting a green card now, I'll get a green card, a slight percentage faster later, earlier.
So somebody out there is happy about this. Congratulations, Brian. You made me feel a lot better. With that, we end today's session.
Whoa! You can't just say.
All right, Brian needs to stop.
No. I mean, no, I don't have any. I just feel bad about ending on that note. I feel bad for both those people. But I mean, yeah.
All right, sounds good. Well,
All right.
all right, so we'll see.